as a court. In that kind of circumstances, a good commissioner. The issue of individual may not work very well.
Thank you, my lord. Maybe we should discuss it at the next colloquium.
Please.
Because there must be instances where I imagine the court may want comfort in numbers. I can think of 3 instantly, but we will discuss that as the entire judiciary at a later date. My lord, I wish you well.
Thank you.
Your Honor, now I would request the Honorable Judge Wasame to ask his questions.
Judge, I wish you well. I have no questions for you.
No. You must ask 1 or 2, please. You and me, make this place happy. Why would you want to back out?
I think we will respect Judge Wasame's position, and I'll now move to Judge Majaja.
Please.
Thank you, Chair, my lord. Like the court you sit in, one of the problems we have in adjudication is the problem of interlocutory applications. You agree with that?
No doubt.
Yes. Now, can you tell us briefly what are the kind of interlocutory applications that are provided for under the Supreme Court Act or rules or another constitution, the types of interlocutory applications?
Oh, in the Supreme Court, we'll have interlocutory applications which touch on a stay of execution. We'll also have interlocutory applications which touch on matters, jurisdiction or lack of it. We'll have interlocutory applications which would come into the issue of Article 163(4), the issue of confirmation as to whether a matter is of general public importance or not. At that level, we would have interlocutory applications coming to court. The other area is the efficacy of 164(6), the issue of advisory opinions. Whether or not this falls into that category becomes an issue and it would arise at that level.
And what of those interlocutory applications, maybe you tell us which type does the Court of the Supreme Court and Court of Appeal have concurrent jurisdiction? Concurrent jurisdiction of the Supreme Court, Court of Appeal and Supreme Court.
One is a stay of execution. The other one is on a confirmation or otherwise on whether a matter is of general public importance. In those two, we would have that kind of a situation where the two courts get involved.
And for a certification application, is it necessary to have a decision of the Court of Appeal in the first instance, or you can go straight to the Supreme Court?
For certification, it is twofold. Certification would arise from the Court of Appeal, and if the Supreme Court feels that they would want to deal with it, they can deal with it on their own, either approve of it or disapprove of it. But again, you can go to the Supreme Court on first instance.
And lastly, on the issue of jurisdiction, under what circumstances would the court or Supreme Court entertain a third appeal? You understand what I mean by a third appeal? An appeal from a decision of the Magistrates Court.
That would be under very, very extraneous circumstances. And the jurisprudence of the Supreme Court is that if this has to arise, then this matter must have been litigated from day one, from the Magistrates Court to the High Court to the Court of Appeal and to the Supreme Court. That is the only circumstance where this would arise.
It would have been, but all matters are litigated from the Magistrates Court. What makes it different, or what is the difference between that third appeal that would have been entertained and the one the court would say there is no jurisdiction? What is the difference, if there is? I'm not saying there is, but if there is.
So my understanding of this stratum is that we would move from the Majesty's Court to the Supreme Court in very exceptional circumstances.
Okay, and tell us those exceptional circumstances. Those are the ones we want to know.
Circumstances where there is a disagreement at the Court of Appeal, the Majesty's Court, and this matter goes to the High Court. The parties again do not feel like they have had their share at the High Court, and they go to the Court of Appeal, all the way to the Supreme Court. And this again must come under the criteria of interpretation of the Constitution, interpretation of the Constitution, and the other aspect of the practice of the Constitution.
Okay.
And those two sets or set terms, this would arise. If any matter comes from down there all the way to this on those two parameters, it would be a feasible matter for the Supreme Court.
So in election petitions concerning the county assemblies, can you tell us what the jurisprudence has been in relation to jurisdiction of the Supreme Court?
Jurisprudence has been that, firstly, the effective jurisprudence of the Supreme Court in terms of in relation to the jurisprudence is that all these courts are competent and able to deal with the matters constitutional. So you cannot use that as a competence and ability as an excuse to go to the Supreme Court. So in the instant case, the Supreme Court has put it that matters which come from the Majesty's Court concerning the county assemblies must end at the High Court. Okay. That is our current jurisprudence.
Okay.
So, and
I'll leave it at that. Let's move to another area of law, which again is very important in the Supreme Court. One of the principles of devolution is that county governments have a source of revenue, let them govern and deliver services effectively. That was it's one of the principles.
Yes.
So, how has the Supreme Court contributed to development of this principle, and probably share with us one or two cases?
One, there was the advisory opinion on this subject, on the issue of revenue, where there was a stalemate between the National Assembly and the Senate on revenue allocation. The Supreme Court came out very, very clearly and brought out the formula or the solution to this by suggesting that they form a mediation committee, so that when we have disputes relating to revenue allocation, the committee, which comprises of members of the Senate and Assembly, will be able to thrash this out and come up with an amicable solution to the issue, or an outright solution to the issue. That is my understanding of the whole thing.
And what did the Supreme Court talk about the Commission on Revenue Allocation? What did it say about that Commission on Revenue Allocation in that particular advisory opinion, if it said anything?
The Supreme Court gave it supremacy over revenue allocation, but pegged that to sensibility and reasonableness, so that in the exercise of the powers of the Commission for Revenue Allocation, they would have to do it constitutionally. They would have to do it in accordance with the law.
so that is the decision of the Commission on Revenue Allocation binding or advisory?
The decision on the Commission on Revenue Allocation is binding, but can be challenged.
Okay. And finally, you are aware of the African Charter on Human and People's Rights.
Yeah.
And it is binding in Kenya.
It is.
Okay. You have been in the ELRC. What labor rights does the Charter protect? Maybe you can give us an exposition very briefly in terms of the labor rights under that Charter, because they are binding in Kenya.
The labor rights which are encompassed in the Charter are the right to work, the right to dignity at the workplace, the right to, pay for labor, the exchange between labor and capital. Basically, the Charter gives what would even say is also, envisaged in Article 41 of the Constitution. Article 41 of the Constitution, and all the labor laws in this country, the Employment Labor, the Employment Act, and the other operationalizing labor laws of this country.
And are there any decisions of the Africa Commission that are relevant, or any instruments that are relevant under this treaty in explaining or expanding the right to work that you are aware of?
I am not aware of any.
Okay. Thank you very much, and thank you, Chair.
Thank you.
Thank you very much, Honorable Judge Majaja. Now I request Commissioner Mashadi Ajero to ask his questions. Commissioner.
Okay, thank you. Now, I only have 2 questions for you, my Lord. The first one. Now, if you go to the Supreme Court, if you look at even the way the Act that governs the Supreme Court is designed, is the order of seniority in terms of the appointment. Now, so effectively it will be judge number 7, the effect of which is that will be expected to do a little bit more than the others, even in terms of developing judgments where there's consensus, drafts, and all that. Now, when I look at your experience as a judge for the last now 9 years, you've mainly been involved in, employment and labor relations matters, so to speak. Now, Supreme Court, of course, has, the kind of matters that you deal with go beyond what you've been dealing with in the last 9 years. Not to underestimate what you've been undertaking, but just to recognize the wide purview of what you have to deal with in the Supreme Court and the attendant learning curve. Now, coming to the question, do you think that that would be a challenge in itself in terms of, hitting the ground running as soon as you are appointed, if we were to appoint you, considering your experience, which has mainly been in one particular field of law?
Thank you for that question. We must appreciate that it will be limiting, in the sense that for the last 13 to 9 years we've been in practice in one single line, and that has permeated the last 17 years of my practice. I caught up with labor at the Judicial Service Commission in 2003. To answer you is that we have our broadness and our personal abilities. Limiting as it may be, we are able to push in and do the learning. These interviews were declared about, we were shortlisted about 2 months ago or so. Before that, the Supreme Court was a stranger to us. We did not require any jurisprudence on the Supreme Court. As we speak now, I can bet that we are 60% through. That is why we are able to sit here and prove our case. So this becomes a learning process, and we have not been disapproved in terms of energy. We have not been disapproved in terms of ability to enter and take charge. It is not a big issue as such. We shall just get in, appreciate our position, take charge, and move on through education, through exposing ourselves, through consultation. But admittedly, that kind of practice where you've been in one line or one focus line, and earlier on in another, I mean, that is a family law and succession earlier on, and now labor law can be limiting. That's a very precise and honest answer. But we can beat that outrightly because of our very nature, aggression and speed.
Okay. Now, my Lord, the second and final question. You know, I'm just thinking, as a commissioner, we've just appointed your sister as a Chief Justice from across the hill, you know. Probably if you threw a stone, probably it would reach the homestead, I don't know, because I don't live there. Now, I'm just wondering, because you know, judges are wise men. In fact, they are wiser than us as a commissioner. You know, the public, when they sit before a judge, they know that a judge is a very wise person. Now, put yourself in our shoes as commissioners. You're a brilliant judge. There's no doubt you're answering questions well and all that, and you're competent by all means. But considering the realities that you have to deal with also as a commission, and visit a situation whereby tomorrow we say it's you, after we've just appointed your sister, how would you deal with that if you're in our shoes as a commissioner?
Thank you so much for that brilliant question. I expected that today, and if it is skipped, I would have been very, very surprised. Let me give you my political theory on ethnicity. I don't use the other word. The word of tribe, I don't pronounce it because I think it is not realistic. It is just a figment of our poor relations. One, ethnicity has never been an issue, and I'll demonstrate this. I went to Alliance High School in 1974. All other factors were constant. We would have judges against A, B, C, and D, and E, and that was that. We left the place, no issues, no injuries, no nothing. In my time at the University of Nairobi, I mean, all other factors were constant. The only requisition for a student of the University of Nairobi was just reading and reading only. I'm even surprised that we did so poorly because we didn't have any other business apart from reading. Food was available, hosts of residence were available. If they were not available, we were taken to the hotels and we were given. All other factors were constant. No issues of ethnicity. To me, and in mind that ethnicity has even become a discipline of study, my position has always been that it is not realistic. It's a creature of our own imagination, it's a creature of our own poor governance systems, and it is something we should be able to thrash out. People like you and me, I mean, who are in this country and have the wherewithal to thrash out these things, should sit and give, make a decision on this. It is not real. A good general walks to the battle with the best that he can at the forefront. This idea about diversity and what have you for Kenya, maybe for now, yes, because of our perverted governance systems in the past. We may have to deal with that one. But for the future, let us sharply rise up and think out of this, because it is not real. Such that good enough, you have my sister as the a Chief Justice of the Republic of Kenya, and on the other ridge. If we use theory number 1, I may not be eligible. I may not be the best of material. Everybody may make a lot of noise about it, and I would justify them. We know where we are coming from. But using theory number 2, it would not make sense. The Supreme Court should have the creme du creme of this society. I belong there. So what, barring 1 or 2 other issues, what we should have in this sense is bringing out our best generals to the war front and leading into battle, and we will sing into victory. To clarify or to polish my answer, that may be a big issue, and a big issue which I considered even before I came for this interview. But for now, I will leave it to the commissioners. But in the future, I mean, all the good brains in this place should come out and chat it out and tell Kenya and Africa that we are getting lost on nothingness. The issue is not ethnicity. Tackle the actual issue and deal with your matters, so that you and me can sit freely and ably and do what we can for Kenya, what we can for humankind, without any regard to our backgrounds, because those are not real to me. Thank you.
Okay. Thank you, my lord. It's a really tough one, but I wish you well.
Thank you. Let's see what happens in the course of the week or next.
Thank you very much, Your Honor. Honorable AG Commissioner, it's your turn.
Thank you very much, Honorable Chair. Good afternoon, Judge.
Good afternoon, sir.
You indicated earlier that you are in favor of writing individual judgments.
Yes, I did.
For the Supreme Court. Would you please tell us, have you identified any area or areas where you may give direction and leadership in terms of jurisprudence and its development if you were appointed as a Supreme Court judge?
I am a constitutional lawyer. That is an area I have studied and written on. It's an area which, is upmost in my interests. I may shyly also say that I'm an authority on the subject. It's my area of specialization. On this, I would offer leadership.
How have you demonstrated your expertise, my lord?
One, at the University of Nairobi in 2005 and 2006, when we went for our upper law degree. I specialized in constitutional law and government. It did not essentially carry that name, but that was my area of study, where we did matters touching on the Constitution itself, constitutional comparative constitutional law, and other matters on democracy and the legal process, that kind of thing. In my write-up for my LLM thesis, titled Towards a New Constitutional Dispensation in Kenya, the Politics of the Constitution and the Constitution-Making Process, I tackled that subject very, very effectively under Professor H.W.O. Okello, and it's called the topmost mark. I thank God for that, which is a demonstration that governance has always been my issue. I have vied for NITHI. I have vied to come to this commission because of my IQ and sensibilities insofar as governance is concerned. We are saying that this is our area, and we own it cumulatively with everybody else who is in that discipline, and we can make a contribution in that line. I have also practiced in other areas, family law and succession, labor. We are able. Thank you.
Since your LLM and your political aspirations, have you at all demonstrated your expertise and legal scholarship in this area?
I have not had any further write-ups. I have pursued my career as it is.
Thank you, my lord. Let's move on to another aspect. As a judge of the Supreme Court, you would be asked to nominate or participate in the nomination of one of your colleagues, and you yourself would be eligible to become the representative of that court to the Judicial Service Commission, correct? Correct, my lord?
Yes, sir.
What attributes would you look for in the person to represent the court to the Judicial Service Commission?
One, ability. Firstly, let me say that at that level, any judge of the Supreme Court is capable and competent of appearing before, representing the court in this commission. But specifically, if that was very, very necessary that we nominate one and get him to the Supreme Court, we would look for ability and agility, flexibility, the team power in the candidates, issues on HR, because HR comprises a very, very critical part of the functions of the Judicial Service Commission. So we'll be looking for a leader who is all round, a leader who is able. Not one among his equals, but one who would be able to do it better than any of the other 6 members of the Supreme Court.
And where would collegiality play a role in your determination of who to send?
That is where I started. I said that from day one, it could also, and this is a problem we also have in our small court, the Employment and Labor Relations Court. We are 12. We've gone to elections twice, which would be easier in the circumstances, unless a member of the court opts out and says that I'm not interested, like I have insofar as my court is concerned. I've always said that I don't want to be principal judge. Let it go to anybody else, but not myself. On the same footing, we could have a rota, seniority or juniority, whichever is earlier, so that everybody is able to, because competencies, abilities. So the other issue is choice. Do I want to be there or don't I want to be there? So that in that rota, everybody takes their fair share. When the time reaches, you just get there automatically. We don't have to go to elections. Elections, we know them in this country. Where do they take us? I remember I got 3 votes when I voted to join this commission. 3 out of 4 or 2. That is what elections are.
Thank you. Sorry,
do I do the finesse of my answer? Collegiality yes, would also come in several senses of the word. Assuming my approach, my formulas, my everything doesn't work, would have to sit as a court and agree that this is a big issue, yes, representation in the Judicial Service Commission, yes, but it's not a matter of life or death. So how do we go about getting one of us to be a member of, to represent us at the Judicial Service Commission? And through, involvement, through consensus, in a very friendly manner, get one of us to come to the Supreme Court, to come to the JSC, because it can bring friction. And you remember we are only 7 or at the best 9 in the future, and that can be extremely dangerous. So collegiality is utmost. It is a primary. It is cardinal. It is very, very important. We must move around with each other, cajole each other, buy each other tea if we can, or any other drinks, weird or not weird, and come to a conclusion, to a consensus as to whom we take to the Judicial Service Commission.
Thank you very much, my Lord, for answering those questions.
Please, thank you. It's been a pleasure.
Honourable Chair, and nothing else from me. Thank you.
Thank you very much, Honourable AG. It's now the turn for Commissioner Gishohi to ask his questions.
Thank you, Chair. Judge, good afternoon.
Good afternoon, sir.
I want us to look at another angle. In this case, I want you to focus to you as a state officer, because as a judge of Supreme Court, you are also a state officer, and you are bound by Article 10 of the Constitution. When you look at Article 10 of the Constitution, as a state officer, one of the principles of governance, one of the principles and values of governance is sustainable development. Sustainable development. What is the role of judiciary, in your view, in enhancing this principle of governance under Article 10?
Thank you. Many of us in the judiciary, and particularly judicial officers, mistakenly believe that we sit here to write judgments, and you carry your files and do blah blah, and in that imagination forget that you're in governance, and at the center of it, our decisions are determinants to governance patterns in this country. You're either directing this way or the other. This is the way we ought to go. This is the way we ought not to go. And that way, we are in the center of governance. And we are in control of the governance patterns of this country. That is why we are an arm of government, like the other two. So in this regard, judges should always have appreciate their positions as a transformative leaders.
Appreciate, that is one. Two.
Number two, you must make decisions which are pro-development and pro-Kenya. You are not going to allow situations that you are making decisions that stumble Kenya, unless that is really the spirit of the law, which would never be. No law would come out with a situation that stumbles us in our development patterns.
Okay, from that basis, Honorable Judge,
please,
I want you to look at our medium-term programs, MTF, and I want to look at the 4 key agendas that the government is in the process of implementing in the country as we sit here this afternoon. The government is currently undertaking 4 agendas, key agendas.
One is the provision of housing. The other one is medical services to the Kenyan citizenry. The next one would be sustenance of a rule of law kind of a situation where we are able to run ourselves, our governance patterns in appropriate manners in accordance with the Constitution and the laws of this land. And what is the last one? It is evading me. Given a little more time, which time we don't have, I'll be able to pick it.
Okay.
But the politician is me, is failing it.
Okay.
Thank you.
Let's move.